Good evening, everyone, and welcome. Thanks so much for joining us. I'm really pleased to be chairing this evening's webinar organised by junior labour lawyers on the UK's international trade after Brexit. This event's the second in a series organised by JLL on the impact of Brexit, following last week's webinar on workers' rights and movement of people. Special thanks to John Morgan and Ahmed Namazi for the hard work they've put into organising the series. There'll be future events over the coming months, so look out for invitations to those in due course. I'm Daniel Jones. I'm a member of the Society of Labour Lawyers Executive Committee, and in my day job, I'm a solicitor advising clients on trade and WTO law. In terms of context, I think it's fair to say that come Christmas Eve, there was a serious collective sense of Brexit fatigue. When the Trade and Cooperation Agreement was finally announced, I think it's fair to say that the predominant emotion on both sides of the channel was one of relief. But for those who hoped that the question of international trade would, to paraphrase the Education Secretary, shut up and go away, or at least be relegated to discussions for the very committed such as these, I think I have bad news. Over recent weeks, we've seen an increasing number of reports on the practical implications of the deal for individuals, businesses, and communities. Last week or the week before, the story was about the impact of rules of origin on Percy pigs. Some of you might have seen today the stories about the impact of customs and animal safety controls on the export of products made from real pigs. It's also clear that the UK and EU's trade relationship will be the subject of ongoing negotiations in a number of important areas for many years to come. And finally, of course, the government now has to show that the long line of international partners clamouring to enter into their own trade agreements with an independent UK will materialise. To discuss these issues, we're delighted to be joined this evening by Bill Esterson, MP for Sefton Central since 2010 and Shadow Minister for International Trade since 2016. Anneli Howard, a barrister at Monckton Chambers, specialising in EU competition and trade law. Anneli is also co-chair of the Society's EU Relations and Trade Group. William Bain, policy advisor at the British Retail Consortium and former Labour MP for Glasgow North East between 2009 and 2015. And finally, David Lawrence, senior political advisor at the Trade Justice Movement, which, as many of you will know, is a UK coalition of nearly 60 civil society organisations that campaign for trade rules that work for people and the planet. The plan for this evening is that William and Anneli will provide their thoughts on the impact of the TCA on trade in goods and trade in services, respectively, followed by David and finally Bill, who will address broader questions of international trade after Brexit, the UK's negotiations with third countries, and Labour's trade policy. Each of the panellists will speak for 10, 15 minutes or so. We'll then open up the discussion. If you have questions for all or some of the panellists as they occur to you, type them into the chat box on Zoom. But for now, thanks for joining us, and over to William.
Thanks very much, Daniel. It's a pleasure to join the Society of Labour Lawyers this evening. I don't think I ever quite made it into the Society of Labour Lawyers because although I have quite a legal heritage, having been a law student at the University of Strathclyde in the mid-1990s, then thinking, of course, EU law would be part of my life forever. And then being an academic at a range of universities for about a dozen or so years after that, specialising in EU law and public law. And I always recall, we used to say that, the Dyson view in sovereignty was wrong because, of course, Parliament had fettered its own powers by joining the European Union, and it was only a fanciful idea that the UK would ever be leaving the European Union, and well, here we are. And after my time in Parliament, I have, as Daniel said, been working for the British Retail Consortium as its trade and Brexit advisor, taking the country's largest retail companies, and many small and medium-sized companies through every twist and turn of late night votes in the Commons that I had to comment upon and analyse, and also what the negotiations were likely to bring and what the deal means. So I think my reflections on what the TCA means are really that it is a pretty bog standard free trade agreement. And that comes as quite a shock to some involved in traded goods. Because of course we had the Salzburg attempt by Theresa May to have a regulatory alignment approach and to basically try and preserve some of the benefits of the single market in goods. We had all of those discussions, the cross-party discussions in 2019 about a customs union or a partial customs union or something like a customs union. And of course, to see the text of the TCA itself and to understand what it means, it will mean considerable change in commerce and in industry on traded goods. And I think if we take just one example, the impact of rules of origin. And I remember doing a briefing for our members on the 30th of December, where I did the TCA in 45 minutes. So you can guess what I was spending my my Boxing Day and the days after that doing. And I remember the huge surprise that there was when you went through the terms on rules of origin and what it means for goods moving from the European Union to the UK and then back to the European Union, these being European Union originating goods, which of course now face a tariff on that second importation back into the EU. And I went over it about 4 times because people just didn't get it. They couldn't see that, effectively these kind of distribution chains that had arisen through the single market and the customs union, and which had formed the backbone of much of our supply for retail over the last few decades, had all of a sudden become incompatible with the TCA. And of course, the same is true for goods from the UK going into the EU and then coming back into the UK. Those again will face a tariff on that second importation. And this, I think, shows the difference between a free trade agreement. You can have a good one, you can have a bad one, a deep one or a thin one. The difference between that and a customs union, because you have different customs territories. And that means for distribution chains, you either have to find workarounds, or you have to look at things like customs warehousing, or you have to look at, frankly, relocating your distribution hubs. And clearly, if you look at where we are now, and of course, we still have to get used to the fact that the deal is the deal and that there is not going to be any renegotiation of it. There's no call to Brussels to say, we need a fix. Can we get this changed in the next 2 or 3 months? It's not happening. We have what we have. The review period is 5 years. And so we're stuck with this in its present form until then. And the issue there is that the EU, of course, will only look at these arrangements in the round, and they'll only look to change any of these arrangements if it is in their interest to do so. And for us being outside the club, we really are out in the cold. And so that, I think, is a huge difference that's come to light in relation to this. In terms of the rules of origin themselves, I think they are relatively modern in that they sort of flow from what was in the EU-Japan agreement. But the problem is that, of course, the kinds of distribution hubs, the kinds of networks, a carousel of goods going from the EU into the UK, that was never designed for a bog standard FTA. And so there is going to be quite significant commercial movement and disruption as a result of this. That's also going to be the case in terms of things like food. So we know that the EU and UK could not reach an agreement on equivalence. The UK didn't want a regulatory alignment relationship with the EU and food. So that means we are going to face significant costs with export health certificates, with documentary checks, identity checks, and those checks will only increase in terms of their significance if the UK decides to diverge. At the moment, de facto, we still have the same food regulations. But over time, of course, that could change quite significantly. And if it does, we'll face more checks at the EU border, and very likely at the GB border as well. We're also seeing immense disruption in terms of aspects such as e-commerce. The BRC includes very many of our major e-commerce companies, and we're now experiencing the disruption, something that I identified 3 years ago in January 2018 in the Observer with Toby Helm, this issue about import VAT. So we have a 6-month period where GB retailers will not have access to the EU's one-stop shop to remit VAT payments. And so we're hearing horror stories about consumers in the EU buying goods from GB retailers and facing enormous bills for customs fees and VAT. Those goods being declined by the customer who doesn't want to pay these charges, and companies now in the position of saying, well, it's cheaper to burn the goods than actually to bring them back into Great Britain. And that, again, is an entirely foreseeable consequence of coming out of the common VAT area. And there were the BRC and other business groups tried for 3 years to lobby the government to avoid this. And now we see the results. And of course, the consequence of this now means that British businesses now have to think about establishing entities in the EU, taking on staff, maybe laying off staff in the UK, in order to be able to avoid this crushing bureaucracy and being able to serve their EU customers. And whatever Brexit is for, surely it was never for that. But this is where we are, and this is the deal. And unless we have political changes in the next 5 years, it's going to be with us in this form for a very long time. And I think the final area, which is, obviously causing considerable friction for retailers and other businesses, is of course around the protocol. Now, I'm sure you will remember the first iteration of the protocol, which had the backstop, a UK-wide customs union, and of course, a mechanism for alignment within that around VAT. Now, that wouldn't of itself have sorted all the problems. There would still have been regulatory checks, but that was where the Salzburg element of Mrs. May's white paper was to come in, and would have avoided, if it had been agreed, the foot checks on food, which are very onerous and expensive, and causing shortages on the shelves in some supermarkets in Northern Ireland. And of course, the DUP and others decided they couldn't tolerate that and voted against it. And then we've had the second iteration of the protocol, which of course did away with the backstop, did away with the idea of a customs union, and instead has created a customs, VAT and regulatory border down the Irish Sea. And again, we're seeing enormous problems, companies saying that they can't supply goods to Northern Ireland, e-commerce companies pulling out of the Northern Ireland market. The cost of these paperwork and the checks is enormous. It doesn't fit the reality of supply chains where goods go from Scotland to Northern Ireland within 4 hours. And certainly that doesn't fit with all the onerous requirements for pre-notification on everyday foodstuffs. And so what's likely to be the consequence? Yes, Northern Ireland has a great opportunity with the best of both worlds, access tariff-free and regulation-free to both markets. It could well become a significant manufacturing hub. It's also likely that more goods will be sourced from the Republic of Ireland to be sold in Northern Ireland, involving much less cost and bureaucracy than going through the protocol processes. And I think over time, as the economy of the North and the Republic become more integrated, that will have a driver in terms of the politics. And so that brings us really to the last act of the Brexit drama. If the first was, the period from the referendum up to the withdrawal agreement being signed and the general election, and the second act was what we went through in 2020 with the negotiation, the third act is likely to be one on the very survival of the United Kingdom as a nation state itself. I've described the effects I think that could happen in terms of Northern Ireland. And of course, tonight I'm speaking to you from Scotland, where we can read the polls. We have a huge, crucial election coming up in a few weeks' time in May. And I think that is the sense that the third act of the Brexit drama could be the most intense of the three and most unpredictable of the three, about whether the United Kingdom will even survive as a single nation state after the tumult that we've had since 2016.
Thanks very much, Willie. Really interesting to hear that thought process from the nuts and bolts, if you like, of the deal for individual businesses and members of the BRC, right through to what the broader political context could be. Next, we'll hear from Anneli Howard, who will talk about what the TCA means for trade in services. I was struck by Willie reflecting on the agreement as being a bog standard trade agreement, Anneli, for trading goods. I wonder whether you think the same can be said of the agreement for trade in services.
Good. Thank you very much, and thank you very much for inviting me to speak this evening. After the 24th of December, there was wide-ranging press coverage that the TCA did not cover services at all. Well, the good news is that the TCA in many aspects has pushed the boundaries on services and that actually has gone further forwards than many of the other EU FTAs, including Canada and Japan. So for the UK, obviously services are an incredibly important part of our economy. It's over 80% by value, over 70% of our workforce is engaged in delivering services, and they are valued at over 380 billion euros a year. The EU is our main market for services, and we are their main provider of services. So it's a very important trade relationship. And that sort of features actually in the TCA itself, because if you look at the chapter on trade, which covers both goods and investments and services, the services sections are almost 40% of that whole section. So it is important that they have been given attention and covered, and developments have been made in important sectors. So what I'm going to try and do, I've got about 10 minutes to talk to you. Ambitiously, I'm going to try and cover three main things. I'm going to talk about how the general services works. Then I'm going to just show how legal services and particular things that you might want to bear in mind as practitioners. Secondly, and then lastly, thirdly, talk about MRPQ. And if I have time, for those of you that are litigators, we'll talk about areas of litigation, but if not, I'll deal with that in questions later. So what does services actually cover? So there's a huge section on general services, and when we have 5 specific sectors for telecoms, postal and courier services, digital services, which includes data and e-commerce, and then we have legal services and financial services. So the addition of those specific sectors is a vast improvement on what has been offered in previous FTAs. But even under the general services section, it covers a very wide scope of activities. And so it will cover, you know, broad things such as digital, IT, telecoms, e-commerce, but also individuals, sole traders, micro entrepreneurs, professionals such as doctors and architects and teachers, creatives. You've probably been reading a lot about musicians and tour musicians in the press. To the extent, are they covered at all? Freelancers such as translators and designers. And where it actually sets out, there is a broad range of service models that apply. So you can actually sit here in the UK and you can provide services without moving to EU citizens, but you are also allowed to offer services on a mobile basis, so that you are allowed to actually move to the member state and provide services there under a sort of fly-in, fly-out model. But you will need to check that you meet the visa requirements for doing that, because obviously free movement has come to an end, and UK services providers will no longer benefit from those passporting arrangements and mutual recognition that we've become so used to in 40 years of EU membership. So what the TCA does is it basically creates three broad models on which services can be provided. One is what's called as a contracted service provider. So you'll get perhaps an architect moving to a member state on a temporary basis for up to 12 months or for the duration of a specific contract. The other way is through the independent professional route, where again, you have to have a minimum of 6 years PQE, but you can then move and provide services for up to 12 months. And then there's a sort of short-term business visitors route, where you can go for up to 90 days in any period of 6 months. But don't just think this is a carte blanche, because the body of the actual TCA is quite skinny. The detail is packed into the annexes, and there are over 250 pages of annexes specifically dealing with services, which set out in minute detail what activities can be provided and by whom and on what basis, what conditions. And what the TCA does is it applies what's known as the negative list method, which was used in the Japan-EU agreement. So in those annexes, sector by sector, there are schedules of what activities can be carried out, where you need to comply with national restrictions, and importantly, what activities are not allowed. Those annexes also list out all the rules, pre-existing rules and regulations, which the member states will insist upon, which are not conforming. So it's a sort of exceptions method where they're allowed to retain a whole number of layers of restrictions on particular service activities. And they also have the right to introduce future changes and restrictions as well. So basically what you have is the right to move to your member state, the right to take your spouse and your family with you, but you are very much subject to the rules and regulations of the host state. So in all practice and effect, it's not really that much different from a no deal scenario. And you will need to check, particularly in regulated, or your clients will need to check, particularly in regulated industries, that they are complying with all the professional rules that might be applied by the regulatory authorities in those countries. So it's not a straightforward exercise, and be prepared, you know, in some sectors, for example, in insurance or other financial services sectors, if you are not authorized and you actually carry out insurance or financial, it is a criminal offense. So there can be quite significant sanctions that can apply if somebody is found to be giving services which they are not authorized to do. So that's the warning, that it's although there are non-discrimination provisions, it doesn't really give you that much. You've got to comply with all the rules and regulations. Now, legal services are covered by their own separate section, and that is more progressive than the general services provision. What the services section says is that English solicitors and barristers can provide legal services under their home title. So you can go and you can practice as a barrister or as a solicitor. You need to be registered with the host state authority, but you do not have to requalify. And interestingly, you cannot be required to set up your own law firm or your own office in that jurisdiction. You are allowed to just fly in and fly out to provide services. So it's quite interesting at the moment because the Irish Law Society has obviously accepted a lot of applications from UK law firms to be registered as Irish lawyers, but they're refusing at the moment to offer a practicing certificate on the basis that the London-based law firms are not opening offices in Dublin. So that seems to be inconsistent with the TCA, and we'll see if they change that requirement. But this looks like a brave new world for legal services. It is not the same as the establishment or the services directives for lawyers. The right only gives you the right to practice UK law or what's known as public international law. So international trade law, presumably disputes if they arise with the EU. It does not give you the right, importantly, to advise on EU law. So if your client is caught up in an investigation by the European Commission, perhaps it's breached competition law, or there's a state aid issue, or it's committed some breach of data, they will not be allowed to instruct a UK only qualified lawyer to defend them in those proceedings. The restrictions allow you to advise, but you are not allowed to carry out any kind of representation of companies before the European Commission or before national authorities, or indeed carry out any kind of advocacy, whether that's between the national courts in the EU 27 or before the Luxembourg courts, the General Court or the EU. So whilst UK companies will very much remain subject to the Commission's jurisdiction in all of these types of cross-border activities, they're going to have to instruct a local lawyer in Belgium to represent them in the proceedings and in any subsequent appeals. So what happens to get round that? You'll have known that a lot of UK lawyers have been re-registering, and they have already become qualified in other jurisdictions. So with a bit of foresight, I am now registered both in Ireland as a solicitor. I'm also registered in Brussels as an EU, on the EU list. And I'm shortly to be registered in Luxembourg as an avocat, so that I have my representation in the courts there. And why is that important? Because we have to be able to guarantee privilege. And at the moment, it's not clear whether being registered in one state like Ireland will give you the right to practice in Ireland, but it won't necessarily give you a passporting right to then advise in all the other member states. So it's important that lawyers try and protect their position by getting registration in other and qualification in other states if they want to have a cross-border practice. Now, most of us have done that before the end of transition, so our rights will be grandfathered. But for young lawyers, particularly those that perhaps are still students or those that are still going through their training, they will not have qualified in time to have reached that grandfathering position. So what can they do? Well, you'll be pleased to know that you can still have the right to get seconded with your law firm into Brussels for a temporary period. You can, once you've got 3 years PQE, you can also go and work abroad as a specialist with your law firm. But you may need to get registered with a host bar. And that's where, again, you are subject to all the professional rules of that particular host bar. And if you have to thumb through the annexes again to see what types of conditions are imposed, 14 out of 27 of the EU states impose what's called an economic needs test. So they will only admit you to the bar as a UK lawyer if they consider that there's an economic need for it and they haven't got enough EU lawyers already in Belgium. Similarly, they may say, well, you need to have a local lawyer countersigning any advice that you want to give, or you may have to actually be resident for a certain amount of time or practice from Belgium for a certain amount of time to make sure it's continuous and effective. And there are whole lists of all these types of conditions that are set out by country by activity that lawyers might carry out in the annexes. So it's really important to consult those and also to check the requirements on privilege. Lastly, mutual recognition of qualifications. There was a provision that was inserted very last minute, apparently, into the TCA. At the moment, it doesn't say very much. You know, we've all been used to having the automatic recognition of our professional qualifications under the directives, whichever member state we wanted to go to. That does not apply anymore. What it does provide is that the UK can enter into bilateral agreements with individual bars within member states, and there will be a process going to the Partnership Council to try and create guidance or recommendations about mutual recognition, but there's no guarantee of that. There's nothing in place at the moment, and even if there's good faith and a goodwill to generate that, it's going to take some time to come. So there is no automatic recognition. So to conclude, the TCA is better than we expected on services. It's not ideal, but it is better than nothing. And there is room for improvement, either through bilaterals or as part of the 5-year review process. So let's watch this space.
Thanks so much, Anneli. That was great. And I'm sure lots of junior labour lawyer members on the webinar were listening intently to you clearly describing there what the impact of the deal would mean at the start of their career. So thanks for that. If anyone has questions for Willie, Anneli, or the rest of the panel, do use the Q&A box, and we can then come on to the questions after we've heard from the next two speakers. So we've heard then what the TCA means for trade in goods and trade in services between the EU and UK after the end of the transition. Clearly, at the same time that the UK was negotiating its future relationship with the EU, it was also thinking about what its future trade and investment relationship would look like with the rest of the world, both third countries that the EU had agreements with, but also with third countries like the United States, Australia, New Zealand, who the UK government had seen as priority negotiating partners under an independent trade policy. Next, we'll hear from David Lawrence, and perhaps David, you'll reflect on the role of civil society in terms of shaping that new trade and investment relationship between the UK and the rest of the world. David.
Thank you, Daniel, and thank you everyone for having me on this call. As Daniel said, my name is David Lawrence. I am the Senior Political Advisor at the Trade Justice Movement. We represent 60 civil society organisations, NGOs, faith groups, trade unions, trying to campaign for a trade policy that works for people and planet. And a lot of our focus ever since the referendum has been on new post-Brexit trade agreements and what these proposed new deals will mean for environmental protection and for social welfare. I'm also, I should say, a member of the Labour Party, and I co-chair the New Diplomacy Project, which aims to help develop Labour's foreign policy. And I think this event really couldn't have been better timed. This month, the UK took back control of our trade policy for the first time in nearly 50 years. And we are currently sandwiched between 2 weeks of the trade bill. Last week, the bill was in the Commons. Next week, it will be in the Lords for ping pong. And there are some huge questions raised by this bill related to trade, but also the legal and constitutional questions that are thrown up by having an independent trade policy, particularly around the role of Parliament in scrutinising trade agreements and the level of transparency that is afforded to the public during negotiations. All of these are questions that the government has not answered yet, but will be incredibly important as we develop our own trade policy. I don't pretend to be a lawyer, and I'm conscious that I'm surrounded by lawyers on this call, but I believe we could even see, I think we could see Miller-style challenges if the government launches negotiations which fundamentally change the rights of citizens, but without consent from Parliament. And currently there is no role for Parliament in initiating or setting up the mandate for negotiations, but trade agreements affect a huge swathe of rights from digital rights and privacy to investor protection, intellectual property, and environmental protection. So that's a big question, but I want to be forward-looking in this, and I think it's true that in the midst of everything, Brexit does provide a genuine opportunity to develop a democratic, socially and environmentally just trade policy. I believe, and my organization believes, that Brexit was a mistake, but we mustn't fall into the trap of thinking that the EU's trade policy was perfect by any stretch. And just this month, the EU has signed an investment agreement with China, which almost overnight seems to have stopped German politicians from criticizing the crackdown on political dissent in Hong Kong, and or indeed impose any sanctions on goods made from slave labor in Xinjiang province. So there are benefits to having an independent trade policy, and I think there's a real opportunity for Labour to step up and reimagine what that post-Brexit trade policy could be like. And so I just want to run through three things which I'd like to see Labour pursue over the next 3 years ahead of the next general election. And so the first of these is about making trade democratic. After Brexit, the UK readopts a system of parliamentary scrutiny, which dates back to the First World War. It's an archaic rule known as the Ponsonby Rule. And under this rule, the government can initiate trade negotiations without informing Parliament or seeking their consent. Negotiations are done in secret with little to no updates given to Parliament, and deals can be signed and ratified without any involvement of MPs. And in this area, the UK lags behind a number of our major trading partners, including the US, the EU and Japan, all of which give their legislatures a guaranteed say on new trade deals. And I think it's something that ordinary voters across the UK expect that they can write to their MPs with concerns about new deals, whether it's chlorinated chicken or protecting the NHS, any of the things we've seen in the news. And I think voters expect that their MPs get a say over these deals. But as things stand, debates depend entirely on the goodwill of government, and there's no guaranteed vote. In short, the exact opposite of Parliament taking back control after Brexit. And I think Labour's been pretty robust in calling for better scrutiny of trade agreements, and I'm sure this will be a priority of a new Labour government. But I'd also be interested to see a future Labour government explore some more deliberative approaches to trade democracy and foreign policy more generally. I think Brexit showed us that there is this real public interest in this question of what is Britain's place in the world, what is our relationship with our neighbours and countries around the world, and that includes trade policy. And I'm always surprised by how animated people get about the food standards issue and chlorinated chicken. And understandably, people are very concerned about the NHS and its status in trade agreements. And I think all of this calls for a public conversation on trade, which could be done in citizens' assemblies or other deliberative methods. The consumer group Which has held a national conversation of trade, which has produced some really interesting results. I think that's something that Labour could really take the lead on in bringing different people around the country together. Obviously, trade deals do create winners and losers, and they'll affect different industries in different ways. What car manufacturers in Sunderland need will be very different from what Welsh lamb farmers need. I'm also conscious that obviously this is perhaps beyond the scope of this event, but there's this huge question about the State of the Union as well. And I think bringing in the devolved regions, it will be essential. Yesterday, the Scottish Government published its own vision for Scotland's trade policy after Brexit, slightly muddled document, I think, given the SNP's aim of rejoining the EU, but also setting out its own trade policy. But nonetheless, I think it highlights the need for a cross-UK conversation about trade, which doesn't just take place in the corridors of Westminster. So this doesn't replace full transparency and parliamentary scrutiny and everything that Labour's pushing for next week on the trade bill. But I think it's important for hopefully avoiding the kind of reckless division that was sowed by the Conservative government in the discourse around Brexit. And I think we'll see more of that as new trade deals are agreed. Secondly, I'd be really interested to see Labour explore non-trade cooperation agreements. As things stand, the most powerful international treaties, and I'm aware that maybe that's not the way I should phrase it, surrounded by lawyers, but from our perspective, the most powerful international treaties are trade deals. Compared to human rights agreements or UN treaties, trade deals have far greater powers of enforceability, essentially because they always come with this very real threat of trade sanctions, and that's baked into the agreement. And I think on the left, we've been very good at opposing big and powerful trade agreements, which undermine citizens' rights. The most prominent example is probably TTIP, the mega US-EU deal that collapsed. But I think we're less good at exploring alternatives for enforceable agreements which aim to protect citizens' rights and also protect the environment. So, for example, trade deals often give investors the right to sue governments for regulations that damage their profits under the ISDS system, investor-state dispute settlement, which Labour and others on the left have rightly picked up on. So I think that's an important critique to make, but the critique tends to focus on the interests, how these deals are designed purely in the interests of corporations. And I think it would be interesting to think about what an alternative system might look like, perhaps one that actively gave citizens, ordinary citizens, the right to take investors to court if they were to act in a way that damaged the environment or threatened public health. The exact things that we have seen investors take governments to court on, we could see that reversed. I'd certainly be interested to see that explored. I imagine the Society for Labour Lawyers is fertile ground for that, because I certainly don't have the solution. And similarly, I think you could get trade deal-like enforceability on environmental issues and climate cooperation. And there's a promising example of this in the Agreement on Climate Change, Trade and Sustainability, or ACTS, ACCTS, between New Zealand, Norway, Switzerland, and some other smaller countries. I think it'd be really interesting for Labour to explore that and to look into whether the UK could join that and then play a leading role. Bill's nodding, so I assume that means the front bench team's already looked into that. I think that's sort of, about exploring ways in which you can bake in these other aspects into the way that we do trade agreements, rather than just opposing. And my organization is, I think, as guilty as anyone else on the left of opposing trade deals without always proposing alternatives. And thirdly, I just wanted to very quickly talk about China, partly because this is somewhat personal to me. I'm half Chinese and I grew up in China, and I'm a member of Chinese for Labour, and I'm very aware that China is in the press a lot at the moment, obviously with the pandemic, but also with ongoing trade wars. And I think there's a real opportunity for Labour to pin down the government on its policy towards trade with China. There is now cross-party concern about both human rights abuses in China, whether it's the oppression of Uyghur Muslims or the crackdown on dissent in Hong Kong, but also concern about China's strategic challenge to the West, its aggression in the South China Sea, the arms race on artificial intelligence, ownership of major utilities in European countries, and so on. And in last week's trade bill debate, Labour worked with backbench Conservatives to come very close to defeating the government on an amendment on genocide, which would have required the High Court to make a determination about whether the Chinese government is committing genocide in Xinjiang. And I'm sure we'll see more of that next week. But this cross-party consensus on human rights and China's strategic threat is not reflected one bit in the UK's trade policy. Conservative MPs were quite rightly quick to criticise the EU's new investment treaty with China, but the UK already has an investment agreement with China, which actively protects Chinese investors in the UK, including companies like Huawei, from policies which damage their interests. And the agreement has no national security or human rights exemptions. And London remains a prime investment target for Chinese capital. The city's interests in China run very deep. HSBC and Standard Chartered, two British banks, both came down in favour of the Chinese Communist Party's national security law in Hong Kong last year. So I think Labour has a real opportunity here to anticipate and stay ahead of the Conservatives when it comes to China policy, and particularly on human rights, and to hold them to their own words. And I think we would have let ourselves down if Ian Duncan-Smith and Tom Tugendhat were leading the moral argument on this, because I think there's so much that Labour can add. And too often the Conservatives talk the talk on human rights and ethical trade and so on, but then they essentially give the Department for International Trade free rein to do whatever it wants. And when push comes to shove, the government will pick free trade, we've seen, over human rights. And it's up to Labour to make the moral case for a reformed trade policy after Brexit. So those are just three areas: trade democracy, international cooperation agreements, and China, which I think Labour can take the lead on in reimagining our trade policy after Brexit. And I'll leave it there for now and look forward to the discussion.
Thanks so much, David, and for striking such an optimistic tone, particularly at the end there, which I thought was very welcome. So now we'll hand over to Bill. And Bill, really interested to hear your reflections on both the wish list, if you like, for Labour's trade policy that David set out, but also your reflections on what Willie and Anneli said in terms of the impact for businesses, small and large, of the TCA. So Bill, over to you.
Thanks, Daniel. Thank you very much to everybody for joining us this evening, and some very well evidenced research by all three of our panelists so far, and I think I'm extremely grateful to all of them, because they've added to my thinking, if nothing else. I was first elected to Parliament in 2010 in Sefton Central. Willie had been there a year when I got there, and I shared with him and 50 or so of his Scottish colleagues an interesting first term, and then they were all gone apart from Ian Murray, and I'd like to see some of them back, whether that's Willie, but certainly somebody representing that seat again. In order to do that, we have to address these sorts of issues, and I think Willie was absolutely on the money there about the impact on the United Kingdom and the Union here. And I took on the trade brief in 2016. I have now opposed the government from the front bench on the trade bill, not once but twice, because we got to 2019, the government pulled the legislation because they were losing. They now have an 80-seat majority in the Commons and are far more confident. But as David was just saying, that doesn't guarantee things when it comes to trade. And I think the fact that votes are up for grabs, and there were 8 Lords amendments brought back to the Commons for votes last week. It won't be 8 next time, but it'll still be 3 or 4. Just shows the potential for international trade to have such a huge impact on our country. And international trade agreements and international law is such that it's not just because of the imposition of tariffs, but because of the way international law is structured, that it takes precedence over domestic law. So any agreement that you sign up to, including the 1986 bilateral agreement, investment agreement with China, takes preeminence over anything that we do here until it is renegotiated by both parties. And that is why it's so important to get these things right, quite apart from the impact they have. And it's why it's so important that there is scrutiny and understanding that these things affect so widely. But there are 3 brief areas I'll just speak to. I'll speak to the Trade and Cooperation Agreement with the European Union. I'll speak to the proposed free trade agreement with the United States, although that is looking increasingly less likely, and then some comments on future policy. The choice we were presented with on Christmas Eve was between the deal that has been signed with all of the gaps in it that there are, and no deal. Now, no deal would have been even worse, and there are some elements of this agreement that do look remarkably like no deal, as Anneli was saying on some parts of services in areas like insurance. But we can all recount just already in the 27 days of January how badly the government has negotiated, how many gaps it has left. Willie was talking about some of the things that the food industry was desperately trying to get the government to make sure we're included, without success. Fish, having to compensate Scottish fishing industry. We've got musicians, because the government wouldn't agree to a 90-day visa, so musicians can't travel into the continent of Europe without a full visa. We have the situation where so the point with fish was there aren't enough vets. Well, who knew? Everybody was shouting at them, there aren't enough vets for the kind of checks at borders that are needed, not just for fish, but for anything to do with animals and animal products and plants indeed as well. And there aren't enough customs agents. This is just down to lack of planning and preparation. We've heard about Welsh lamb, we've heard about the Cheshire Cheese Company who can no longer export. I've got a fish processing plant just half a mile away from where I am this evening, which employs 140 of my constituents. Unless some of the areas that haven't been sorted out, it turns out the global tariff wasn't properly considered. Unless that is sorted out, those 140 jobs will go, because they'll have to move to Holland, because they just simply won't be competitive because of the tariff that is applied to shellfish. And we have this unbelievable situation, the Department for International Trade advising British companies to open an office in the EU 27 if they can't cope as things are. That is no kind of way to be treating businesses or working people, and it is no way to have continued. And Willie made an excellent description of the problems of the common VAT area, which not just the BRC but a number of organisations warned the Treasury about. And manufacturing rules of origin. It isn't just cars. This is in food and drink as well, isn't it? This is about sugar that goes into anything that's made with sugar in it or flour in it. How on earth do you unravel these things and apply them quickly? And none of these things have been sorted out. So our exporters are in a really, really bad place again and again. And then the Prime Minister on Christmas Eve said there would be no non-tariff barriers. It isn't just about tariffs, it's about all the delays, it's about all the paperwork, it is about all of the arrangements that you have to prove, whether that's on rules of origin, on the component parts and ingredients in manufactured goods, or in just demonstrating what is in what you are exporting. And I won't add too much to what Anneli said, but the points are well made about mutual recognition and acceptance of qualification and authorization for trade in services. And the government promised us that there would be no dilution of areas like workers' rights. Well, we've already seen that unravel. Kwasi Kwarteng, he, the author of Britannia Unchained, and numerous other documents over the last 10 years where he's made perfectly clear he wants to dismantle workers' rights, now say, oh no, I'm not at all. But they are hell-bent on ending the Working Time Directive with serious consequences for working people in the UK. And they can do it because of the way the TCA has been written. Because unless it affects trade, they can change standards and conditions and regulations. And of course, that is such a vague phrase, deliberately so, I'm sure, that it's very difficult. And with all, I hesitate to say things like this because there's a lot of lawyers on this call, and I'm not a lawyer. But how do you prove whether it affects trade? And they know full well that's the situation, and it won't end up with workers' rights. We've already seen it in chemicals with REACH, where the Environment Bill has weaker powers for the regulation of chemicals in the UK than we've enjoyed as part of EU REACH, where we have the highest chemical standards in the world, and therefore we don't see things like the appalling abuses, the appalling damage to human and animal life and poisoning of the watercourses that we've seen with companies like DuPont in North America, let alone with companies elsewhere in the world. So that's where we are at the moment with the TCA, and moves me on to the United States. I mentioned workers' rights. Happily, we now have Joe Biden in the White House. You know, who'd have thought we'd have gone through an attempted coup by a sitting president and his supporters to get there? But thankfully, we are now there. And I was overjoyed to see him signing the executive orders. There are so many good ones, but I think rejoining Paris for me is the number one. But the commitments on workers' rights are incredibly powerful. He won't sign a trade agreement. He won't be involved in trade agreements without trade unions being involved in negotiations, and he won't sign anything without protections being in those agreements. There is an irony here, because it was when Trump was in the White House that the US agreed to the new US MCA agreement with Mexico and Canada, and the workers' rights were strengthened and safeguarded in that agreement because of something that I think it was David referred to it, which is the way that the US carries out its scrutiny of trade agreements. So they allow their trade unions involvement in the negotiating process and access to the negotiating texts. And it was the US TUC who spotted the problems in Mexico of union busting, strengthened the agreement to protect trade unions and workers in Mexico as part of that US MCA agreement. But with Biden, it's even stronger again. And this government, of course, made great store in the run-up to the new year that we would get a deal with the US, with Trump before he left the White House. We'd sort out the tariffs on Scotch whiskey and the damage being done to Airbus in the dispute with Boeing once we'd left the EU. And of course, none of it's happened. And we still have a situation where the Scotch whiskey industry is losing £30 million a month because of those tariffs. And another example of the UK government simply failing businesses or workers in this country over a trade agreement. Now, I mentioned that Joe Biden has rejoined Paris. Climate and addressing the existential threat of the climate and environmental crisis is at the heart of trade agreements. It's there because all too often in the past, the provisions in trade agreements have been used by fossil fuel investors to sue national governments. This is often done by American companies through Canada, and Canada has been on the receiving end of a lot of this. And that has undermined efforts to decarbonise the economies across the world. It's something that has to change. We had amendments to that point in the trade bill committee, a number of which I moved and spoke to. And there is a big contrast, having said the Trump administration got it right on their new deal with Mexico and Canada. We look at the ongoing challenges, I think it's fair to say, with the US, because the US negotiating objectives from the Trump administration targeted pharmaceuticals. They're very keen to tackle drug prices. They don't think they get enough. And they see the NHS as a big block on that, not just for this country, but for Europe as a whole, as a market for American pharmaceuticals. Medical equipment, state-owned enterprises are referenced, public services as we would know them better. And of course, they have lower standards of food production and animal welfare, and any trade agreement on those negotiating objectives would have completely undermined our farming sector in this country were we ever to have signed up to it, which is why, whether it's on the NHS or on food standards or indeed on both, why we were so keen and still are keen to include public services, food, animal welfare, environmental protections, and the climate in the trade bill when it next goes to the Lords, which is next Tuesday. So there will be amendment on standards that includes all of those points. And the agreement with the US doesn't end with the fact that there's not going to be an agreement directly with the US. There's a thing called the CPTPP, which is the Comprehensive and Progressive Trans-Pacific Partnership. It's the successor to TTIP. It's an American agreement, but the Americans, with Trump in the White House, decided not to join it. It has 11 countries on in the Pacific. It includes Canada and Mexico, and New Zealand and Australia, but it has countries like Vietnam in it, and Japan, and Malaysia. And it has low standards on agriculture. It has an ISDS provision in it. It has all of the elements of trade agreements that were we to join it, and were we to have to apply it in full, would leave us wide open to a lowering of standards on imports, which would undercut our domestic farming, and on access to our NHS in a way we've described. And because it includes countries like Vietnam, it would leave us open to the import of products that have been made using cheap labour with poor labour standards as well. So now that is a stated aim of this government, to join the CPTPP. It's something they're going to make an initial approach to in the next few days. And there'll be an announcement from Liz Truss on it. There'll be another announcement because she announced it several times already. It's also likely the US will reconsider joining it. And the other country, of course, that's interested in joining it is China. So we could join a trade agreement which has the US with its low agriculture standards, its pharmaceutical interests in coming after drugs in the UK, and China with its human rights and workers' rights record. And to David's points about the about China and trade. Now, we backed the Alton Amendment. We'll be doing it again in the Lords on Tuesday. We also want to have our own amendment, as we did last time in the Lords, because whilst there's much good in the Alton Amendment, not least that it gets a lot of Tories backing it, there is a potential problem with it. It's just a very high bar for action because it has to get court agreement. So we need to have a parliamentary version of that enables Parliament through its select committees to be considering areas not just in human rights but more widely, sorry, not just in genocide but more widely in human rights. So that's the approach we'll be taking, but it isn't just about China. We have these continuity agreements, which is what the trade bill was supposed to be all about. The government has already re-signed agreements with Cameroon and Egypt, which have nothing been added to improve the provisions on workers' rights in either, or human rights in either of them. And they have an appalling human rights record. I was just looking today at the terrible execution numbers in Egypt. 155 people, was it today? You know, absolutely dreadful, and we made no comment on that when we re-signed an agreement with them. In Vietnam and Singapore, the political agreements that contained the areas on human rights were excluded from what the government re-signed, and we signed an agreement with Turkey with no mention of either human or workers' rights. And this is where Labour, in the coming months and years, will be going on human rights to really be taking these arguments on, to be arguing that trade agreements must be about addressing human rights, workers' rights, the environment, climate, and animal welfare, food standards, human health too. David was asking earlier whether my cat would be in the video. She has just wandered across the back and moved the laptop. But it was the mention of animal welfare. I mean, it's, you know, it's a very clever cat. It understands what's going on. Yeah, I mentioned human health there. Now, when we see habitat destruction, and this was addressed in the Environment Bill yesterday as well, there is a strong recognition now that as habitat is reduced, as species decline, with 50% fewer species now than we had in 1970. it leads to the transfer of diseases, zoonotic diseases, which is what we are now going through in the pandemic, and it makes pandemics more likely. And trade agreements are again where these things can be and should be addressed. On policy through procurement, and the government procurement agreement is another opportunity to address some of these things with progressive policies that make sure through supply chains businesses have to operate in a progressive way, looking after workers' rights and sustainability in production. I'll just say a few words about scrutiny. David's quite right. We do have to improve the parliamentary scrutiny and civil society scrutiny. I talked about the American model briefly. We have laid a number of amendments. We will be trying to change the way the government does scrutiny, both in the Lords and then back into the Commons in the trade bill. At the moment, we have a situation where Parliament only gets to consider an international trade agreement with all of the challenges and issues that we've just been talking about, if the government provides parliamentary time so that the opposition can call a debate and vote on it. So it's entirely in the government's gift whether this happens or not. It's something called the Constitutional Reform and Governance Act, which is an update of the Ponsonby Rule of 1924 that David referenced. The reason we have that position is because it's what we used whilst we were members of the European Union, because the European Parliament was carrying out the scrutiny for us, and trade agreements were not a national government competence. Totally unsuitable now. The government so far has resisted our attempts to introduce scrutiny. So there'll be an attempt to pass an amendment in the Lords that looks at a debate and vote on the negotiating objectives that allows select committees in both houses of Parliament to have access to negotiating texts. During that process, I would hope that we would see the unions and business groups and civil society engaging as well. And then a final vote where it's not in the gift of the government whether it happens or not. And these are crucial changes that are more in tune with good practice around the world. I think there is scope to go further, actually, but that's probably as far as we're able to go at the moment. I mentioned these continuity agreements, and as I just in conclusion, really, we signed an agreement with Japan. The government's projections are that it will see trade increases of 2.6 billion in the next 15 years. Just to put that in context, the agreement we were party to as members of the European Union with Japan, they estimated would increase trade by 4.3 billion. That gap between where we were going with increases in trade and where we are now, with agreements that are supposed to be exactly the same, is replicated right across the 40 agreements that have been, well, they haven't all been re-signed yet, that are due to be re-signed with countries across the world. And you won't need me to tell you of the various projections for how much GDP will fall as a result of us leaving the European Union. The chances of the government replacing that trade are very, very concerning. They're putting their money on deals with New Zealand, Australia, with the CPTPP that I mentioned, with trade on the other side of the world. Trade is most effective in goods and largely in services too, with your near neighbours. Geography really matters in trade. There is a real irony as well that having left one trading bloc because we wanted to a return to parliamentary sovereignty, the government's plan for international trade is to join another one with 11 countries on the other side of the world. We'd be joining it without any chance of influencing its content because it's an existing agreement. We'd have to take what we are offered. And we have taken back control from the European Union, only, it seems, to give it away to the Pacific Rim. Make of that what you will. Thank you.
Thanks very much, Bill. That was great. I want to open up the Q&A by picking up where you left off, which is those agreements with third countries. As I think you suggested, if you didn't perhaps say explicitly, it's unlikely that trade with the Pacific Rim or any other third countries is likely to make up for the losses from our new relationship with the EU. But nonetheless, I'm interested to hear from Willie. Do these third agreements factor as commercial priorities, Willie, for your members, and Anneli, perhaps for your clients? And to the extent that they do, what are your members or clients looking for in terms of these new agreements with third countries?
Well, they are important. I mean, in terms of food, most of the food which the UK imports does come from the European Union. So on the food side, the TCA was the bare essential of what was required. But it could clearly have gone a lot further if the government had made very different political choices, and would have cut out a lot of the extra costs and delays and red tape. In terms of non-food, it is a different picture. I mean, a great deal of what we import does come from rest of the world trade. So the GSP countries are important, and we understand the government is going to, launch a consultation on the GSP this year, and that's going to be really important for business and civic society and for the Labour Party. But a good chunk of that trade does come from the continuity agreements, and that's why we were on the government's case quite a bit over the last 4 years to make good Liam Fox's pledge that every one of them would be rolled over. Of course, they weren't rolled over in time because he originally said it would be done by 2019, and they needed the extra time in 2019 and every day in 2020 to get all but a few rolled over. There are issues still about rules of origin again. So remember, the South Korea agreement requires a renegotiation in 2022 on rules of origin. We're already seeing problems in industry with the interplay between the TCA and the Switzerland-UK agreement on rules of origin, and the Turkey-UK agreement with the TCA on rules of origin. And again, that's going to lead to quite sweeping changes in commercial practice and supply chains and distribution chains. It goes on and on. I think the government didn't have much choice other than to try and limit the damage by rolling these agreements over as best they could. But it was very noticeable in terms of Switzerland that they had to make different agreements in terms of goods from that in services. And we still have some continuity agreements that have not been rolled over. So, for example, Ghana, and what the government did was make a special deal with Kenya, which created some adverse consequences in the rest of the East African community as well. So they've got Ghana, in which they're embroiled in a messy negotiation. There's Algeria, there's Albania, some of the Balkan states as well still need to be done. So they have not honoured the pledge that they made, that they would have secure all of these rollover deals. We have some which are incomplete, we have some which will need to be renegotiated, and it's a very patchy picture.
Thanks, Willie. Anneli, would you like to pick up that question on UK third country agreements?
Yes, I mean, obviously I see it from the litigation end of the spectrum. So, whilst there are opportunities for businesses with these new trade agreements, previously they've been acting under the umbrella of the EU agreements, where it's all been a kind of a system of these multiple agreements all interlocking with one another. Now, of course, there's going to be a whole panoply of different agreements which companies have to operate in. So they've got to make sure that they're complying with different standards in different agreements. And there may be different tariffs that apply. I mean, if you think of the UK as often a hub where we're getting expert components imported from Asia, which we then repackage, assemble, and then re-export to the EU. And I'm starting to see businesses they're having to pay levels of duties coming in from Asia. They're paying anti-dumping tariffs on their imports, and then they're also, because of the rules of origin, having to pay additional taxes and charges when they're re-exporting. So it's really affecting the just in time. So if those new agreements come through, that may help them in that it will lower the level of tariffs for imports, but there's still the interrelationship between the two, which have not been agreed as a cohesive whole. The other thing, Bill was mentioning that, there is this loss of GDP in the transition from these agreements to from the EU umbrella into the continuity agreements. I think the other thing that businesses probably haven't realized yet is the loss of individual rights, because obviously the EU agreements, the treaties were actually a form of free trade agreement in themselves, but they were unique because the provisions of the treaties had direct effect, which meant that UK companies, for instance, if there was a unlawful subsidy, if there was a preference and an economic advantage given to a national champion in some way, they could actually take direct action and sue the French government or the German government. Now, because of this transition to free trade agreements, that is all interstate dispute. And there's set mechanisms in each of these agreements where they go to political consensus and dialogue and conciliation. It takes ages. If that doesn't work, that remedies might be imposed. They may not work. You then go on to an escalation process and ultimately end up in arbitration. You get a ruling, but it may not be complied with. There's no direct immediate remedy in the same way that European law gives companies to challenge action and to sue for damages against the member state. And that has all fallen away. So it's a very different litigating and, to actually enforce your rights, it's a very different arena now, because companies are going to have to lobby governments. They're going to have to try and persuade them to act on their behalf. Bill mentioned, you can't start saying there's an effect on trade. You can't just bounce that around as conjecture or suspicion. You've got to show real evidence, but there's no real mechanism for the individual companies to participate in that process. They're not in charge of the litigation, and they're not going to be able to necessarily guarantee how the government presents it on their behalf, or what political compromises they're going to accept. So there's a huge loss of rights there as well. Thanks,
Anneli. I also wanted to ask a question of Willie and perhaps Bill, in terms of discussions that I know you have with businesses, small and large. Willie, you made clear that this is the deal and we're stuck with it for at least 5 years. John Morgan has asked, how are your members responding to that? If it's the new normal, if you like, how are members of the BRC responding and adapting to the impact of the TCA on their operations? I know we're a month in and that'll be an iterative process, but interested to hear what actions they're taking, what actions they're considering. And Bill, perhaps the same question to you in terms of the discussions that you've been having with businesses.
Well, the other thing that was sort of regrettable about the sort of the mad rush on Christmas Eve was we got no adjustment period. So you had guidance on rules of origin coming out on the 29th of December, me fielding calls from businesses later that evening. The guidance on e-commerce between GB and NI came out at 10 o'clock in the morning on the 31st of December, supposedly to be used from 11 p.m. that same day. It was extraordinary. And I think the problem is that businesses have been given all sorts of cliff edges here. And for small businesses in particular, it's totally overwhelming. And it's not surprising that some are saying it's not worth the hassle for us to sell goods to customers in the EU. We're not going to register for the VAT number in Germany. It's too much hassle. We're pulling out. We'll just concentrate on the GB market. So you've got quite a lot of that going on. I think there is a lot of deep thinking going on about things like customs warehousing, where you organize distribution hubs, where you manufacture a product. So, you know, the delightful example of Percy the pig, made in Germany, imported into the UK, and then re-exported into the Republic of Ireland and facing a tariff on that second importation. So there'll be a lot of decisions about where to make and distribute goods from. But this is, there is no avoiding this. This is the inevitable jump from going from a very integrated set of supply chains under the customs union and single market to an FTA. And there's a world of difference between the two. I think that some of the things that we said, that the consumer is going to get a worse deal, clearly that's the case if you're buying things from e-commerce providers who are not on a part of a platform. Clearly it's the case in terms of some of the delays that we're seeing in products already manifesting in stores in Northern Ireland. You know, the economy takes a hit over 10 years of -4%. So effectively, it is not a sort of, you know, a burst tire. It's a bit like a slow puncture over that period. We're going to face a 0.4% headwind every single year for the next 10 years as we try to grow the economy. And a lot of that pain is being felt by businesses. In a sense, if you were a Leave voter in Kent, well, I suppose it depends where you are in Kent. If you can see the M20 in Manston Airport beginning to fill up with lorries, then, you know, this isn't going to matter to you. If you don't travel a lot overseas or seek to provide services in the EU, it's not going to matter to you. Maybe in some of the red wall seats, it's not going to matter to people either. But the people at the front line are really businesses, because it's small businesses who are having to make this system work day by day. And it is almost a new challenge every single day.
Yeah, thanks, Willie. And Bill, I don't know if you want to pick up on that one, and I suppose what the role of scrutiny and parliamentary opposition can be. As Willie says, the deal's the deal, but, you know, on the customs cock-ups, if I can call them that you talked about, what role can opposition play to amplify the voice and concerns of business on the TCA?
Yeah, I think it's really important we keep pushing what the individual circumstances, the examples, you know, the emotiveness of these things matter. You know, they do grab the attention, they get the media coverage. No government ever likes to resist it for very long. I mean, look, it took, I mean, maybe you need Marcus Rashford to get involved in these things. I mean, it worked with free school meals. I mean, I say that they're going to try and ignore the Labour Party and the SNP and everybody else for that matter, because they've got an 80-seat majority, and that tends to be what they say. But yeah, there are some Conservatives who are rattled by this and will continue to be, and we have to keep plugging away. I think, you know, opposition from the position we're in is a very long process, and we have to be patient. We have to keep plugging away, and we have to know what's going to work. The difficulty, of course, is we can't quantify. There is no alternative world where we can say, here's what the world looks like if we didn't leave the EU, with a 4% uplift in GDP after 10 years. So you can't ever prove it. I mean, I'm minded to say it's a bit like, you know, we you know, people are, I mean, it's really hard to say this. 100,000 people have died in the UK from COVID. I don't suppose there's anybody on this call who doesn't think the government couldn't have done better. You know, there are so many ways in which it could have done. But of course, we don't have an alternative, a parallel universe where we can show what that looked like. And I think this is a similar sort of point. And for a lot of people, they zone out of it. They don't pay attention to it a lot. And, you know, in the same way as with COVID, people are kind of minded to give the government the benefit of the doubt because they just want it to get better. I think it's a bit like that with this now. And of course, the two do come together and create a very, very difficult set of trading circumstances. So I'll just say this as well. I think being productive, which is something David referred to, we need an export-led recovery. We need an industrial strategy that makes the most of investment into green technology in particular, that is across the economy, that's into manufacturing and into services, where we can use some of the advantages we do that David referred to, small though they are on the trade, the independent trade policy side. There are some. I think there are opportunities because we're very good at certain things in renewables and in transport and in agriculture as well, actually, to sell around the world. The government has, really damaged and tarnished the British brand that was very popular around the world in goods and services. So we've got to fight in our hands to retain that. And I think for an opposition party, for the Labour Party, a patriotic approach here, it isn't just about sitting in front of the flag, which Keir is now doing. It is about saying, look, we are really good at this stuff. Let's support these businesses and these industries and these jobs, and really push internationally on how we trade. And my sense is that's, to me, that's the kind of the end product of all of the higher level stuff we've been talking about, that will really cut through, if anything is going to, with businesses and with workers, wherever they are in the UK.
Thanks, Bill. Great. We need to wrap up in a moment, but I just wanted to give David the chance to say a final few words as well. And I think, David, both Bill and I liked that note of optimism in your remarks. And perhaps in your final remarks, you could also tell us, David, if people were interested in getting involved in the work that the trade justice movement and wider civil society groups do on building and participating in that new national conversation that we want to have on trade policy. Perhaps you can let people on the call know how they can get involved.
Yeah, sure. And I definitely, I'm not feeling hugely optimistic about the government's trade strategy, but I think I wanted to outline some positive things that Labour can do, because I think broadly there's probably, very crudely, sort of two mistakes we could make when it comes to trade policy on the left over the next 3 years or 3.5 years before the next election. I think one is that we just talk about Europe and how much better it would have been. I mean, obviously this event is about Europe and it's right to fully scrutinise the TCA and so on, but I think there is this world in which the left just sort of goes on about how much better it would have been if we stayed in the EU over the next 3 years. I don't think that's particularly helpful. I don't think it's what voters are interested in hearing about. And it is also just not constructive, because we're not going to rejoin the EU, before the next election anytime soon. Hopefully we will one day. And then I think the other mistake is that we just say no to everything. That every single thing the government opposes, that our only line is, no, we don't like that. We don't like that trade deal. I think the fact is we won't like what the government's proposing, but I think the onus is on us to be proposing something else positive, and setting out a vision of what trade could look like outside of the EU, but from a left perspective that is putting people and the planet first. And that's what I was trying to do a bit. And if that comes across as optimistic, then wonderful. In terms of the trade justice movement, we are made up of organizations rather than individual members, but some of our member organizations are good ones to join and get involved with, for individuals. So Global Justice Now, Tradecraft, I think, ActionAid and War on Want. I think all of those are ones that are sort of reasonably easy to get involved with, and they all work on trade. Obviously do follow us on Twitter, have a look at our website. But yeah, we're sort of a coalition gatherer of multiple other organizations that have an interest in trade.
Thanks so much, David. And thanks to all of our other speakers tonight, Anneli, Bill and Willie. I really enjoyed the discussion, and thanks for all of your perseverance. I know at the end of January, talking about Brexit again was quite a hard sell. So thanks for joining us, and look out for further details of upcoming SLL events in due course. Thanks, everyone.
Thank you very much.